I have accessed
Yes.
it personally.
Okay. And the rest? Or you're waiting for Angel Gabriel to come down and blow
We
the
have.
trumpets. Oh, you have. Okay, fantastic. Okay. So are there any questions with the cat? Or your groupings or everything or anything cat related so that we can move forward knowing everyone is on the same page? Any questions? Okay. I take it everyone is all right. Okay. So, Ibrahim, over to you. Do you want to put up slides or will you just be discussing it
Yes,
without slides?
I'll put up slides.
Okay, go ahead then. I think you have the permissions. And as Ibrahim is preparing himself, I just want to let you know have you all received the timetable for the exam? No one has received a timetable?
We have.
Okay, so you know when LST is
We
going to be.
received the details.
Okay. All right, so you all know the date. And then also so it's on the 31st in the morning of this month. And then also the cat, you will note that the cat, really the questions are set just like exam questions. In fact, they are exam questions. And how I want you to approach this is, yes, you have a week and it might seem short, but these questions are meant to be answered 3 questions within 3 hours. So, or is it, no, 4 questions within 3 hours, I beg your pardon. So please keep that in mind so that now you are preparing yourself for the exam, which is going to be in a couple of weeks' time. And so at the end of this, when you come and do your presentations, what I would like you to do is exchange your group work with each other. So it serves as a revision and a aid memoir in preparation for your exam. The exam has been set, it's been approved as we speak. So please, please, please prepare. Everything that we have covered in this semester will come up, especially this topic that we are doing, which is why I'm taking extra care to make sure you're all understanding what is going on with this topic. So please pay attention, ask the questions where you can, so that now we make sure that as we leave today, because today is the last taught class that we're having, that you're all understanding the principles and you all go back and do your research on case law, whether it's Kenyan case law or foreign case law, so that you're able to answer the questions, fully and comprehensively, and that you look at all angles as you are considering the questions. So keep in mind that the CAT questions that have been set for you were actually exam questions. So get used to the format, get used to the style of the question, and make sure that you're breaking the questions down so that you make sure that you answer each part of every question. So you don't answer the question in your mind, answer the question on the paper. That's number 1 rule, because sometimes you get answer sheets and you realize someone just saw one word and then decided the question is about A when actually it's about B and C and D. So make sure by now, I don't think I need to teach you how to answer an exam question. I'm sure you're all experts at it, but just make sure, it bears repeating, break a question down to its constituent parts and make sure that each part is being addressed fully and clearly. Don't just assume and then go on a ramble and a rant and a tangent, and then you lose marks and time as well. All right. So over to Ibrahim.
Thank you, Malim. Is my slide visible? Can it be seen? Okay.
Yes, it can. It can. And then also afterwards, please share. And this also goes with, I think it was Arike last time. Was it Arike or Chelsea? Please share those slides so I can put them send them to me so I can put them on the classroom as well.
Okay, thank you.
All right.
So the case is Goodman's Goodmon's daughter versus the state of Iceland. Iceland, yes, Iceland. So I'd like to give a background to this case before we handle the facts and the other parts, just to give a background of really what happened. So we start with in 1996, there were two doctors, Dr. Stevenson and Dr. Jeffrey. They registered a company in the United States. The company was called Decor Genetics. So in 1997, they came up with an idea of forming or creating a gene bank to the Minister for Health of Iceland. So basically, what they were trying to do in this case, they wanted to make use of the medical and genealogical records of all Icelanders, and then they wanted to combine this information with the genetic tissue samples of the entire population. So basically, they wanted to create a gene bank. So in 1998, the Minister of Health introduced a draft bill to the Parliament, and there were a number of changes to that bill. Thereafter, the Health Sector Database Act was passed. That was 17th of December 1998. And then in 2000, the company was given an exclusive license for commercial exploitation of genetic database for 12 years. So basically, it provided for the entire population to be encompassed in a gene bank. So they were creating a genetic bank, something of that nature. So in 2000, Icelandic Biobank Act was adopted, a piece of legislation that will enable the court to negotiate access to. So basically, this act also was passed to enable now the court to operationalize their ideas. In 2001, DICO now agreed citizens. Now this was creating an opportunity for the citizens who intended to opt out. So they were given that opportunity to opt out. Basically, opt out is like you don't want your information to be included in that gene bank. So it also required participants or those people whose information were put in the database, they will remain anonymous through an encryption process. So the act provided for recording of the encrypted medical records of all Icelanders who do not opt out. So if you don't opt out, then your information will be contained in that database. So in this case, one aspect of that act that was a bit controversial was that there was no possibility of relatives of the people of the deceased to claim for an opportunity or an option of opting out. So if your relative passed away, or your father, your mother, whatever, and you wanted now the information to be removed from the gene bank, then you are not given that opportunity. There was not that opportunity to apply or ask for opting out. So again, something also that was there is that there was what they were calling presumed consent. So there was no provision for consent, which is implied, but they were saying presumed. So they were assuming that everybody consented the information to be included in the gene bank. So in this case, what happened in this case was that in 2000, there is this lady who's 15 years old. Her father passed away, and then she made a request to the medical director asking for an opting out clause or opportunity to remove his information from the database. So in this case, the director refused because he said the act has no provision for individual to make that application of opting out on behalf of their deceased parents. So her first port of call was the district court, whereby she filed a case in the district court against the decision or administrative decision of the director So she was asking for a judicial recognition or the right to have a right of to exclude her father's information in the database, because she claimed that from her father's database an inference can be made on her personal information, and so therefore she was asking for a right to exclude his information from the database. So in this case, the court held that the court held that the medical information included in that case is not personally identifiable. So again, they were asking for her standing to challenge her father's information be included in the database. So they were saying that she doesn't have any even standing. So you are not, you don't have that right to come to the court because you don't have standing, because it's not your information, it's your father's information. So in this case, her guardian now approached the Supreme Court, the Icelandic Supreme Court. So again, there were two courts. There was a district court, and then from the district court, if you're not satisfied with the decision of the district court, then the next port of call was Icelandic Supreme Court. So in this case, what were the issues? One of the issues the plaintiff was challenging was whether the plaintiff has legal standing, because that was one of the grounds the district court actually rejected her case. So the question is whether she has a standing in this case, and then number two was whether there were requirement for informed consent. Was informed consent required in this case? Whether there were data protection issue with the act itself, and whether there is lack of independent review mechanism for the health sector. So these are some of the issues the Supreme Court delved into so that it can make a determination in this matter. So we'll start with the first issue of legal standing. So in this case, the court based decision on the appellant's right to privacy. So basically, she says that first, the appellant does he has privacy in this case. So there is a reasoning that the data related to hereditary characteristics of her father, and that case it affected her as well, because she had a personal interest in this matter, because the personal information of her father is linked to hereditary characteristics, which also can be linked to her as a person. So the database it provided for inclusion information about the citizen in the database, but there was no provision for descendants or other relative to execute an opt-out. So basically, it was closed already. You cannot apply for any. There's no way of you opting out from that on behalf of the relative who passed away. So the court in this case, what it observed was that the appellant herself could be derived. Information about the appellant could be derived from the information related to the hereditary characteristics of her father. So again, there it was observing that she has personal interest in this in her father's information, because inferences can be made from her father's information to the appellant in this case. So again, the other aspect it considered was issue of informed consent. We said earlier on, the act was working on a presumed consent, and we know that informed consent, if you look at Helsinki Declaration and International Declaration on Human Genetics, these both instruments, they emphasized on consent which is informed. But in this case, this act was working on a presumed consent. So instead of what the court observed was that instead of informing the population of Iceland about the healthcare database and all that it compasses, and subsequently asking citizens for consent to have their medical records entered into a database and to link this database with the genealogical and genetic database, the Icelandic government adopted national legislation containing the provision of presumed consent. So there was no provision for informed consent in this case. So what was the justification the government was using of coming up with this presumed consent? The justification provided by the Icelandic government for the use of presumed consent is that information is supposed to be non-identifiable and that Icelanders can opt out. So we'll see that really is the information non-identifiable, because the government will say that the information is non-identifiable. So basically, whatever information that's in the gene cannot be used to identify or make inference on another person. So the question that needs to be answered with respect to the requirement for informed consent is whether information contained in the database is personally identifiable. So basically, this was now the code, what it was, the measurement that it was creating, whether now that information is personally identifiable. And then let's see what the court was now observing. So the court in this case argued that due to the richness of the data and the fact that the health database would link up with the genealogical and genetic database, individual person could be identified without use of complicated things. So basically, whatever information that was there will enable now will be used to make inference on another person. So basically, when you talk about richness of data, the court was considering aspects such as marital status, education, profession, municipality of residence, age of person, as well as specific diseases. So these were transferred to the database, but the name and address of the patient and their families were omitted from the database. So the database was containing some information and then it was also omitting some information. And then that's why the argument was that it was not personally identifiable. But the court was observing that, yes, you've omitted the name, you've omitted the address, but you included marital status, they were including education, profession, municipality of residence, setting. So the court was observing that this was identifiable. And in that case, it said that informed consent should have been there. In that case, the act was saying there's no informed consent was not consideration for them. So the other aspect the court looked at was data protection and whether the act contravened the constitution on the aspect of privacy, on the provisions on privacy. So in this case, the court said or held that information that involves private affairs of identifiable person does not fall into the hands of a third party who do not have legitimate access to it. So whatever information that belongs to a private should not fall in the hands of a third party who have no legitimate right to access. So in this case, again, the court were accessing information of Icelanders, but the question was that do they have legitimate right of access? So again, the other aspect was removal of personal identifiers such as identification number and name and address may not be enough to provide anonymization. So again, we say that the issue of richness of data, this aspect is linked to the first point we've discussed. So if the data is of sufficient richness to enable identification of individuals simply by adding various factors such as education, profession, medical status, etc., together to reach an almost certain conclusion with regard to the identity of the person, then this is a direct violation of privacy and data protection legislation. Again, they were observing that the act was in contravention of the constitutional provision on data protection. The other aspect was lack of independent review, because the act was there, but then there was no provision for independent review. And now what it says is that lack of independent review mechanism for the health sector database, if there is no security in knowing which monitoring bodies are responsible for overseeing the health sector database and what regulation their monitoring power is based on, the constitutional provision of privacy cannot be granted in sufficiently reliable way. So one of the main concerns of the critics of the healthcare database is the fear that the database will not be subjected to oversight by an independent ethical body. And in fact, this particular act, from the onset, the Medical Association of Icelandic Medical Association were opposed to this act because of lack of independent review. So in conclusion, this is what the court stated. The decision of the Icelandic Director of Health to deny the request of Gunbonta, the information about the medical record of her father who died and said that should not be entered, then that decision is reversed and the right of appellant to prohibit the transfer of his information into the database is upheld. And then she was awarded a damage of Corona 1,500,000 in cost. So again, the critique to this, in this particular case, when they were coming up with this idea, they were saying that Iceland is genetically homogeneous. That was the argument when initially they were conceptualizing the idea. So the question is, then if the population is homogeneous, the question is, should legal standing then be given to each Icelander in such a case? Because if we're homogeneous, then it means the information of any of the Icelander will be affecting any the other Icelanders for that matter. The other critic will be that could each Icelander then challenge the inclusion of every other Icelander in the database on the basis that Icelandic population is homogeneous? I think that one I've mentioned. The second critique was that every Icelander could be able to take his parent to court and demand that they opt out. So your parent may want his information to be there, but again, you can take your parent to court until you have to opt out because the information also affects me or influence can be made on. So this decision actually is a bit complicated and created problem. It could create that kind of problem, which was not the intention of the Supreme Court. Then the other part is even grandchildren now, who will come many years after. They can take their grandparents to court asking for opting out again, because you see 25% of their genetic material could be derived from their grandparents. So again, the issue of grandchildren laying a claim against their grandparents, this is another complication that can arise with this kind of decision. And then finally, the court omits an important third aspect and does not discuss the issue of possible existence of key to decoding information, because they were saying that this information is encrypted, but this information can be decoded. Some IT gurus can come up with a software to decode all those information and, like WikiLeaks, kind of thing, and publicize this information, which it was argued is encrypted. It can be decoded, and this comes now in the public domain. So this was another critique against the decision. I think that's what I've come up across in my research. But what I realized also is the issue of consent. This case did not deal with consent in great detail, and I think that's what also some of the researchers, another critique they were also raising was that the aspect of consent was not properly discussed in this case, and that was another critique that they were also adding, that consent was not really properly pronounced by this court, and it's so like kind of there was kind of lacuna with respect to consent in the way how the court pronounced itself on the matter. So Malimu, that is what I have the class. Back to you. Thank you, Malimu.
Thank you very much, Ibrahim. That was very well done, very clear and well presented. Any questions on the presentation before I add a little onto it? Any questions from anyone? All right. So thank you very much, Ibrahim. If you can just, thank you. Let me just put up a slide. Just want to add a few things. So I like the background that was given. That was very good. A case like this needs some background because some of the issues discussed may not be so commonplace or obvious or even make sense necessarily when you're coming across it the first time. So let me just put up the slides. Right, so I've just put up a slide giving some brief facts, just adding on to the background. So a lot of it has been presented by Ibrahim. Just want to add that that this biobank was actually approved by the Icelandic parliament in 1999, and to create this company called Decode Genetics, monopoly to create a database, a comprehensive genetic database for the entire population of Iceland, which at the time was 280,000 people. Can you even imagine a country with 280,000 people? I don't think we have counties with less than that or even that number today. So the advantage or the rationale for having this biobank in Iceland was that the population is relatively homogeneous, and therefore they wanted to boost the national health system by doing research on the population of Iceland. Now, what does it mean? What do you understand by the word homogeneous, and what are the implications in this context? Can anyone attempt? What does homogeneous mean, first of all? Let's not presume that everyone knows what that word means. And then what are the implications? Keep in mind what we've discussed in the last two sessions on this topic when it comes to the characteristics of genetic information. Anyone? Class rep, Ronald, lead by example. Go ahead. Ronald, are you there?
Yes, I'm here, sir.
Okay, go ahead. What does homogeneous mean?
Homogeneous in this context, I would say, means uniform, or uniform, or with this.
Go ahead. Just go on and read what you're reading.
Uniform or with similarity. Things, yeah, in that sense, like when it comes to genetical data.
Genetic, not genetical. That's not a word.
Genetics, like there is uniformity when it's tested.
So give me, to help the class and everyone understand, and even to make it clearer to yourself, give a parallel in Kenya when it comes to discussing homogeneous. Give an example. So we've said Iceland at that time had 280,000 people and their homogeneous population, which, as you've rightly put it, the meaning of homogeneous means uniform or similar. So now the implications. Arike will help you. Go ahead, Arike.
So I think the implications of this would be, because of, as we have already discussed, genetic information has the ability to show the information of not just the person from whom the genetic information is collected, but of their relatives, of their community, and sometimes even of their race. So in such a homogeneous society, the genetic information of one person could show the characteristics of maybe even the entire population or a majority of the population. And then in this way, I think also because they're also connected, because I think homogeneity from the point of like populations, it shows that you descend from relatively the same lineage. Maybe you shifted a bit, but you can be traced to the same lineage, the way we trace the Luos, the way we trace the Luyas in such a way. And so in this society, what they're researching will affect the entire society because they are such a homogeneous society.
Good. All right. So, okay. Chelsea, do you want to add on to that? Go on. Go ahead.
On the implications, I remember from, I think, a previous class, you mentioned how the way, because the society or the population there is homogeneous, it would be easy for someone with wrong intentions to make a weapon that is a biological weapon, because it can be used for the same, because the population is homogeneous, so the genetic is is
the
uniform.
genetically vulnerable. Yeah, sorry, go on. Finish your
Yes,
thought.
yeah.
Okay.
So anyone
All
with wrong intention would be able to use their information to make any weapon, and they'd use their genetic information.
Absolutely. So this is now the thing. So because they are homogeneous, the reason why, and that is why I wanted us to understand the meaning of homogeneous and the implications, is because biobanks like this are now quite commonplace, especially in the West. To us, they're kind of a new concept and really hasn't been part of the public discourse at all. If I can't think of any time in Kenya or in Africa even that it has been mentioned, maybe possibly South Africa. But now, yes, so the reason why these biobanks exist, especially in a place like Iceland, is because of the homogeneity of the gene pool there. So it means that it is a lot easier to map out characteristics of that population, because most of that population comes from a similar ancestry. They have similar traits. They have similar phenotypes. When I say phenotypes, I mean how you present. So they are white. Most of them will have blonde hair. Most of them will have blue eyes. Most of them will have, certain features and traits characteristic of that homogeneous population of people, group of people. So you can take the Icelandic people and then swap that with people of the Luo community, or people of like the Luya community, or the Kikuyu community, or the Mijikenda, or you can even take it further down and to a specific clan within a community, which will tend to have homogeneous traits. Now, as opposed to having a biobank in an African setting, where I believe I'm backed up with studies that say Africa is the most genetically diverse continent in the world. It would be very difficult to map out traits in Africa, because we have very many different groups, starting from the main groups, which is Bantus, Kushites, Nilotes, etc. And then within those groups, there are so many subgroups. And then within those subgroups, there are even more subgroups. So the genetic variation is too wide to make a viable biobank research project, because you cannot pick a single genetic trait and then attribute that to a whole group of people, because there's been, migration, there's been intermarriage, there's been influence from the Arabs, from the Chinese, from the Portuguese, from the Indian, etc., etc. So you'll find that it will be very difficult to map out an African gene as opposed to an Icelandic one, which, as we said, has homogeneity attached to it. Whereas with an African gene pool, you can't use the word homogeneous, because there's just too many variations and too many combinations of those variations. So it would be too expensive to have such a biobank in Africa, and to have any meaningful research done that could say, okay, this certain group of people, because that certain group of people that you isolate has probably been influenced by different gene pools from different races and etc., as has been discussed. So keep that in mind. So it is an advantage to actually have this biobank in Iceland, because already from the outset, you know that this is a very homogeneous group of people. There hasn't been much intermarriage over the centuries, or much mixing with people of other races, let's put it that way. Although we all know race is a social construct, so it's not real. But if you want to say people from Africa, or people from South America, or people from the Indian subcontinent or Southeast Asia, etc., they haven't mixed too much with the Icelandic pool. So that means that their gene pool is quite homogeneous and easier to map out than say a South American population, or an African population, or an Indian population. So the Icelandic Medical Association launched a worldwide campaign to protest the commodification of an individual's DNA, because ultimately what was happening is Parliament has approved this process where this private entity collects people's genetic information and then researches upon it and then commodifies it. And we'll touch upon this commodification aspect when we talk about the Greenberg case. Because now when it comes to commodification, you have to ask things like consent. Did I consent to this? Will I get a cut of the money that you make? How long will you keep it for? And who owns what? Do I still own my genetic tissue once it has been collected without my informed consent, and so on and so forth. So now the key issues that come out of that are issues of and these were cited by the World Medical Association, which was protesting this biobank. So the issues there are, and we've discussed these before, but these came up in the in this whole case study, not just within the court, but which was also discussed in the court, but just these are the issues that the Medical Association actually cited. They cited that this project was a great threat to personal privacy, that the data might be encrypted, but it's not anonymous. And you're able to connect. And if you had the right person to go into that database, they'd be able to connect names of people with the actual coded genetic information that was being collected. Another issue that was brought up was a breach of patient-physician trust. As you know, the Hippocratic Oath and patient, just the same way we have lawyer-client, attorney-client privilege, and that a lawyer is expected to keep their client's information confidential at all times, because once you have come to an agreement and on as a lawyer on doing work for a client, then the automatic presumption is that all the information that comes to the lawyer by way of representing their client will be kept anonymous. And this is why even now a lot of law firms go to a lot of pains to make sure that the information that they have is properly stored. They go to a lot of pains when recruiting to make sure that you won't recruit an employee, an associate, a clerk, a secretary who is going to handle information, such legal information or client information irresponsibly, because that has repercussions. The same thing with the doctor-patient relationship. So the Icelandic doctors argued that when a patient is seeing a doctor for one thing, and then the doctor or that hospital or that clinic goes and uses the tissue or blood samples and transfers it even through an act of parliament to this private biobank, then they're breaching with the patient-physician trust. And then the third thing they argued about is ethics. That is it ethical to sell or give away individual genetic data without obtaining informed consent from the patients? Okay, and then there's this issue of opting in, opting out. Is opting out a really valid way of obtaining consent? Because when you're opting out, the obvious presumption is that the information is already out there, it's already in someone else's hands. And then what is the procedure for opting out? Is it a long, convoluted procedure? And opting out also requires that the person opting out has the necessary information that they have now decided to opt out, which is not always the case. So for example, think about now the acts of parliament that go in, that are debated and then passed into law. And there's a requirement for public participation. And everyone should be able to be aware so they can be able to give their input so that they know what exactly it is that is being passed into law. So take this scenario where, and you know how in Kenya, a lot of laws are passed without public participation. So that public participation, then it's impossible to give consent, number one, or even know that you have an option to opt out. And even when you opt out, it might be too late, because that information, copies of that genetic information will already be in someone's database, even though you have opted out. And you cannot necessarily, or rather you cannot practically police once information is held by someone else, you cannot practically police how it is stored, how it is used, to make sure that it's not being sold on the black market, for example, or being given away without your knowledge, and so on and so forth. Okay, so the Supreme Court in 2004 ruled that the law from the Icelandic parliament did not comply with the country's privacy protections. And they cited Article 71 of the Icelandic constitution that stated everyone shall enjoy the privacy of his or her life, home, and family. And they said that this creation of the biobank is actually in violation of Article 71 of the Icelandic constitution. And on the issue of, the arguments about opting out or the safety measures that at that time had been taken or was being argued had been taken, the court also ruled that simply removing names from the genetic information that's been collected or encrypting the information, that is not enough to prevent the identification of individuals in the database or connecting an individual's names and ID number to the genetic information. And now this ruling has created a legal precedent for living relatives who are seeking to prevent the transfer of their records into a database, or even the transfer of a relative's records onto such a database. And now the lessons that have been learned, and this is in tandem with the critiques that Ibrahim gave in his presentation. So there was the lessons learned was there was a failure to ensure that the Data Protection Commissioner, and this is something similar to our Data Protection Act, which talks about the data controller, or the data, which also has a position for the data commissioner as well. There was failure in Iceland to ensure that the Data Protection Commissioner and the Icelandic Medical Association were on board. When this law was passed that allowed this this company Decode to continue with this project as it was. And then also what happened in the aftermath of the decision was that the Decode Genetics announced that it did not expect to ever construct or operate the health sector database authorized by the legislation. And then they proceeded to construct a database based on informed consent. So basically they abandoned the structure that had been approved by Parliament and passed into law, and then they proceeded to create one that was based on informed consent. And also keep in mind that this 1999 was not the first time a data biobank had been done. This was actually a replication of something that had been done in America. There's some really good YouTube videos on this Decode biobank and this whole saga on YouTube. So please do just do a search on Decode biobank, Iceland, etc. And there are very many documentaries that go into detail about this biobank. What were the preceding climate before it was set up? What were the motivations for it to be set up? What did Parliament do? What did government do up until this case and after the case happened, and the aftermath of this case? So please, if you're bored this weekend or after this class, just go click on YouTube and listen to some of these documentaries. They're really good ones. And also it has led to international agreement or consensus that encryption structures or architectures cannot replace informed consent for population genomics projects. So remember, when we're talking about encryption, when we talked about the characteristics of genetic information, we talked about the longevity of genetic information, especially when when you join that with computers. So when you're storing something in a computer as opposed to a filing cabinet in an office, in fact, in many ways, it's safer to store the information, especially genetic information, in a hard copy cabinet in an office, which would have a key and which you would know exactly who has access to it, so that if anything goes missing, there are these 3 people who have access and they're the ones to answer for it. But once it's stored in a computer or on a cloud, then it's open to anyone with decent knowledge of how to hack. So it's not just the persons who are operating the database, it becomes open to hacking from any outside party who has enough motivation or enough reason to go and hack that information. As I was listening to Ibrahim's presentation, I received somewhat, you must have seen this, I received something on WhatsApp, and it was a breaking news. I think Cliff Ombeta, the famous lawyer, Nairobi lawyer, and this was information about a certain person called Wycliffe, and he's a 30-year-old man from Narok who has hacked into the government system and employed himself as an MP, received last month's pay and all the allowances. He did this by adding one more constituency to Nyamira County, and he named it Ombogo South. So this is how simple it is, to hack a system. Someone with enough motivation and means to do it and enough knowledge to do it will simply just go into the system, de-encrypt the information, connect that genetic information with names and numbers and addresses and family members' names, and then privacy has been breached. And then even if consent was given, it is also breached. Okay, so these are the lessons that were learned in a nutshell. These are not all the lessons, but these are some that I picked out that I thought are relevant and can be a starting off ground to more reading and research. So informed consent has to be the basic, the absolute basic minimum that is required, and you cannot leapfrog over consent, and not just consent, informed consent, by saying that, oh, but the information is protected, it's encrypted, blah 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 blah, because that does not negate the need for consent. Because if you have consent, then if something goes wrong, at least you are covered as a biobank, as a hospital, as a lab, even as a data controller, you are covered because consent was given for storage. Now, what happens after that? Then at least you are safe in the knowledge that at least the information that you have has been obtained through consent. All right. We're just going to go a little bit further on consent issues when it comes to genetic information. And these are just what I'm putting up questions to be posed. So when you're doing your reading and research and going through case law, and even going through or listening or watching these YouTube videos, these are questions that you need to have in mind and need to be able to discuss one way or the other, one side or the other. So the questions that are posed are, for example, the ones I put on the screen. Can an individual consent to the collection, use, and disclosure of genetic information that has implications for extended family members? Can I consent to having my genetic information being collected, yet it has implications on my family members? Won't their consent be needed as well? Okay, especially knowing the nature of genetic information and the implications it has on revealing information about family members. Also, another question that you should be asking yourselves is that if, since genomics projects are longitudinal and open-ended, and the risks can usually not be identified in advance. Usually you take the information and then you find out 5 years later, not even 5, that's too long, a year later, 12 months later, that actually this information can be used for an extra purpose or has more applications than what we thought of, which is the nature of what we've been discussing all semester. Can you have future consent? And even if you can it truly be said to have been informed because you didn't know these other implications until 12 months down the line? So that in consent changes now. Does this mean that now biobanks and hospitals and labs have to be regularly seeking your consent as time moves forward and as things change and as research expands and as new applications to your genetic information become evident? Do we have to be sent? Will this biobanks have to be sending us emails every 6 months to be like, okay, we're just refreshing your consent because we found out that, you know, we are trying to do research now into this disease. When we took your information, it was just for disease A. Now we're doing for disease B. Can you give us your consent so before we proceed? And also, is it practical? Especially in a situation like Iceland, where they were doing collecting genetic information for an entire population within a country. Also, what are alternatives of consent? Okay, because now we're talking about consent. We're talking about informed consent. We're discussing whether future consent is even a real thing. Is there a one-time consent, or should consent be consistently or regularly being updated? Can there be consent for a specific project, that when that project changes direction or pivots, for example, because you find something tomorrow and then you're like, okay, we should not be going down road A, we should be going down road B. So at that point, do we seek consent again before we go down that road? Is there presumed consent? Because you've gone to a doctor and you've allowed them to take your samples, is there presumed consent that whatever samples the doctor holds of you or the lab holds of you, they can use it to do any project for any period of time, any length of time? And that's where the opt-out consent comes in, because that's when you are told you fill in the form and then you opt out. Because if you don't opt out, then there's a presumption that you've given consent. Is that really is that ethical to have to have presumed consent, especially considering the special status of genetic information? Can you have blanket or open consent, which means that no one will, after you give your samples, no one will ever look for you again to update your consent? Is there an authorization model that at the point of taking your samples, you authorize for A, B, C, but not D and E and F? Will the parliament have to be constantly legislating on these or giving directives or regulations, such as in the European space? The EU does give directives and regulations quite regularly. Will this be required in this case? Also, is there a need to reconceptualize research as primary use to enable reliance on implied consent? So now we're talking about implied consent. First of all, is implied consent a real thing? And if it is, when does it crystallize? When does implied consent become valid, and when is it invalid? Does implied consent become valid at the point where the researchers have obtained your genetic information and material, once the doctors or the lab or the biobank has sent it to them? So do they presume that if I'm receiving this from the middle person, which is the doctor or the lab or whoever, then I presume there's implied consent for me as a researcher to research this work in any way that I see fit? So I don't have to go back to you as the donor of that genetic tissue to give me a proper signed consent sheet. Okay, so those are now questions that you need to be asking yourself. So now, when it comes to anonymized and aggregate genetic information, so anonymized, basically genetic information which has been made anonymous or has been encrypted, etc. So the general understanding or the general consensus when it comes to anonymized genetic information is that it does not have the potential to be identified. Okay, so that's the starting off point. Where there is no, and this is where the Health Insurance Portability and Accountability Act of Iceland, and it states that where there is no reasonable possibility of identifying a specific individual, either directly, indirectly, through manipulation or linkage of information, there is no need to provide privacy protections. Okay, now that is the position as stated in this act, the Health Insurance Portability Accountability Act. But then it looks like but then it puts a high onus on the people who are handling or anonymizing or encrypting this genetic data to make sure that this genetic information is that you can say quite categorically that this information that we've anonymized and encrypted cannot be linked to any specific individual directly or indirectly, or through manipulation, or through linkage of information. And then you have to back it up with facts, with proof that actually this information cannot be linked to a personal individual. So that's quite a high standard. And I'll wager to say if that standard was put in Kenya, we would never reach it. No information would be exempt from privacy protections. And when I say privacy protections, that means that you have to follow either the Constitution when it comes to privacy, or any specific statute when it comes to privacy, or international convention that Kenya is a signatory and has ratified in Kenyan law. So that's a really high threshold. So it means that it would be very rare for a piece of genetic information or very rare for a company dealing with genetic information to prove without any doubt or categorically that this information they're holding cannot be linked either directly or indirectly or through manipulation, which means then the obvious recourse is go back to that individual patient or person and obtain their informed consent, and make sure that at every stage, if something is changing or the project is changing or the research is changing or the use is changing, you're making sure that at every stage you are refreshing that consent with the person who has donated their genetic information. Okay, and identifying information has been defined under this act as information that identifies an individual or for which it is reasonably foreseeable in the circumstances that it could be utilized either alone or with other information to identify an individual. So this is a statute that has been written basically to basically the net effect of this definition is to basically mandate anyone dealing with human genetic information to always be obtaining and seeking informed consent from the persons who are giving their genetic information for use, either by a biobank, by a lab, by a hospital, and so on and so forth. Okay. Any questions up till there? Because I feel like I've been talking nonstop. Any questions, any comments? Yes, Chelsea? Chelsea Owino.
Yes, sir. Can you hear me clearly?
Yes, I can. Go ahead.
Okay. My question takes you a bit back to biobanks when you mentioned that, in Africa, there are no, biobanks. Like the existence of biobanks is not present because of, the diversity when it comes to the gene pool and whatnot. But then I think I came across something interesting about, the establishment of a biobanking network in Africa. And this was as a result of, COVID-19 and whatnot. So there was this whole idea of, having biobanks as a way to, accelerate the development and evolution of diagnostic tests in Africa. And I think this was as a result of, the outbreaks of COVID-19, and they kept on coming, and the fact that you couldn't even predict who was going to be the next person to be infected, with COVID, and the rapid development and the fact that, the diagnosis wasn't also happening like almost immediately because of the issue of like the medical supplies, the medical equipment, and the story goes on and on. So I would just like to hear, your thoughts regarding that, because I saw something about South Africa and biobanks, and there's this whole story about how, South Africa it is in Africa, but it doesn't necessarily, fall under the issue of like third world, like it's quite developed. So there was this whole storyline. I didn't get the whole gist because I wasn't quite understanding where they were coming from, bearing in mind that, the whole issue is quite expensive. So just to maybe pick your brain a little bit, what are your thoughts, regarding that?
Okay. Thank you for that question, Chelsea. So what I said was that biobanks are not really at the forefront of discussion in Africa. Not to say that they are not existing. I'm sure there's one in South Africa, and I'm aware of one in Nigeria. The only thing, at that time in 1999, when they were trying to do this research, the choice of basing the biobank in Iceland was because of the homogeneity of the population there, because it was deemed that it would be easier to map out genetic traits and genetic weaknesses and genetic strengths of a homogeneous population. So they would it, and then the certainty, the rate of certainty would be much higher with regard to their findings. So as opposed to an African biobank, and then obviously with that would have implications on costs, because then you wouldn't have to you'd spend less time to map out genetic traits, genetic strengths, genetic weaknesses in a homogeneous population like Iceland, as opposed to a population in Nigeria or in Kenya. Nigeria, which has 300 ethnic communities and clans within each of those communities, and Kenya similar, and places like Somalia and Congo, etc. So that was the reasoning behind having the biobank in Iceland as opposed to somewhere else which has too much genetic diversity, which would then have cost implications. So that's number one. Not to say that you cannot have a biobank in Africa or any other place in the world. Of course you can, but then obviously you are looking at costs, you're looking at infrastructure, you're looking at the brain power, where you're going to get these scientists who are trained in this specific field of genetics. I know there's a biobank in Nigeria. I'm not sure about South Africa, but I know that's a discussion that's being had there. There probably is. But now what is not really at the forefront of discussions, and definitely not in Kenya, is although I know Kenya has considered something similar, is what is not at the forefront is actually the implications of having such projects on the population in question, and in particular the African population. Let me talk about what I am reasonably aware of. So that is now the thing. Not to say that there can't be biobanks. Yes, they can, but there's not really real discussion about the implications on the populace, the information that will be held, the regulation of such biobanks, which is the big key factor, because as we've discussed before, the aims of science are very different from the aims of law. Science wants to find out as much as it can in the shortest time possible and be able to disseminate information and contribute to the knowledge pool. So without regulation, a lot of corners could be cut, because yes, of course, they do have self-regulation within those industries, in those sectors. But then their self-regulation would stop where it is an impediment to their research, as opposed to law, which should make sure that everyone is informed, everyone understands what the implications are, and there are also recourses where biobanks have acted unethically, irresponsibly, recklessly, etc., with information, genetic information that they have acquired. Am I answering your question, or?
Yes, you are, and I think you have sort of caused me to be quite interested in this, and just to find out, more information about biobanks and specifically Africa, because one thing I've noticed with this unit is the fact that, there is quite a lot of reliance on common law on other countries. So I think when such a topic has the capability of coming back home, I think that's something that is worth, taking note of. Maybe just as I mentioned very briefly about South Africa, I think we're in May. So in March, South Africa launched a central, biobank network. But then I think I haven't really read much about it. I just saw it like as a headline news. And sometime back in 2013, I believe, they were raising issues of the challenges, issue of storage when it comes to like the human, animal, the plant specimens. Like there was that challenge of where will this particular, specimens be stored. So that was one of the key challenges that they were raising when it comes to, South Africa and the issue of biobanks. But I think just in summary, it is something quite interesting. And I look forward to seeing, the steps that Kenya will actually take when it comes to actually launching a central, biobank network. And I think it will be sort of wise for Kenya to rely on what South Africa has done, like on the basis of, comparative jurisprudence. Because if Kenya can actually sort of borrow inspiration on the issue of the constitution, then I think that there is no harm if South Africa has been successful when it comes to the issue of biobanks and its regulation. I believe that, Kenya can borrow a thing or two from South Africa on how it has, carried out or addressed this topic of biobanks. But it has really caused me to be quite interested, and I think I'll get deeper into it and find out more information about it.
Yes, I think. Thank you for that. I think we're coming to a world where this is going to come to the fore, especially as you rightly put it, after COVID, and especially through forums like the African Union and the various regional forums, whether it's SADC, whether it's EAC, whether it's COMISA, whichever space. Because I think what is becoming clear is, especially when it comes to Africa as a continent, is after COVID, is that certain states or commentators and researchers based in Africa felt that we can't be relying on the Pfizers and the SmithKlines and all those groups when something like this happens, and then we can't do anything to save our populace, and we're waiting for the West to come with some miracle drug and cure. That we should be able to map it out for ourselves, by ourselves, and then also in doing that, then there's some, I guess, level of protection, if that can be said, because it's being done in-house. So there'll be protection of our information that's collected and the use of that information, and the necessary framework, both in terms of infrastructure and legally, is set up to make sure that it's not open to abuse, both from within Africa and also from outside of Africa, so that we have a situation where we don't have, I think if you remember during COVID, the French president was trying to suggest that they should do COVID research in Africa, because he felt, really what was being said in between the lines was Africans are dispensable. So let's use them as guinea pigs for this research. Then whatever we find out when it's safe to use, we take it back to Europe and we use it. So there's that aspect of it where, there's a feeling that if we take the lead and we are not just reacting and looking to the West for as saviors to us, then we can have a handle on the issue of, providing medication that suits us, that is specific to us, and healthcare that is, that is tailor-made for Africans and within Africa for different peoples within Africa. But for me, the question for me has to start with, why are we doing it in the first place? Why do we want a biobank? Why are we prioritizing a biobank? Are we prioritizing a biobank so that in the future we cut down on health costs, so that we have a population that is never sick, or that has ready made drugs and medication that goes direct to that is tailor-made for us, that has zero side effects, that is tailor-made for us? Because there's always been an argument with many products, not just drugs, that a lot of these products that we use were created with the white Westerner in mind. I'll give you an example. Kodak actually, I think you can find this out on the internet. Kodak or some persons in Kodak actually admitted that when they created the camera, the lighting was actually developed with white people in mind. It was never developed thinking about black people with black skin, which is why then, you know, a lot of the photos, you know, that you see taken in the 70s and 80s and 90s, when it takes out, if it's a photograph of a white person, it looks very nice. But if it's a photograph of a black person, it looks weird. You know, the lighting is not correct. They look like, you know, they've not put, you know, pakad mafuta on themselves, or their eyes have a funny red thing in them, or whatever it is. So and I'm only bringing that up to illustrate that a lot of the products that we use are not actually created or invented or made with Africans in mind, or people with dark skin or melanated skin in mind. I don't mean just dark skin, because Africa has a whole, you know, it runs the gamut when it comes to shade. You can be black as a South Sudanese, or you can be albino. I don't know how you pronounce that. I'll say albino. Or you can be albino, but you're still African. But then, you know, regardless of that whole scale of the African skin, a lot of products are not made with that in mind. And so I'm not to talk about cameras. We're talking about detergents. We're talking about soaps. We're talking about moisturizer. We're talking about all sorts of products that get marketed to us, but were not really made with us in mind. And then therefore we have to deal with risks of side effects, you know, to the body, to the blood vessels, to the heart, to, you know, major organs, and so on and so forth. So then back to what I was saying, my question becomes, why do we need this? And why should we prioritize this over other development goals? Bridges, education, general healthcare, and so on and so forth. Then once we answer those questions, and we're able to answer those questions comprehensively, and then now that's when you start designing and building a framework that then makes sure that the African population, whichever part of Africa you're from, the African population is actually at the first in mind when creating these biobanks, and the necessary self-regulation steps are taken. The necessary regulation from governments is created and enacted, so that everyone's privacy is protected and consent is always informed, and there's protection from misuse and abuse, not only from within Africa but also from outside of Africa. That's what I would add to that. Okay, thank you for that question. That was a very good question. Any other questions? All right, so let me continue. Okay, and now just still on this question of anonymization of genetic information comes the question, because everyone now asks when I talk about, oh, we can encrypt, oh, we can anonymize, oh, we can do this, then the question becomes, okay, you can hide that information through encryption, through anonymizing it, etc. But is there a way that it can be de-identified, decoded? And the irony is that biobank is called Decode. It's quite funny, actually. So it might imply that this information that they're storing can be decoded. I don't know. Maybe they never saw the irony in calling the company that. But the question now becomes, can it be de-identified? Can the genetic information that's being collected and stored, can it be decoded, for no pun intended? So some argue that genetic information can never be de-identified. Okay, so now you can keep in mind, you know, the scientific people who are for and those who are against. What did we call them? Promoters and hello? Is anyone there? Oh, am I on mute? No, I'm unmuted. We call them protectors and hello? Hello?
Protectors and promoters, the experts.
The experts, yes. So this discussion leans into that one that we've had before about protectors and promoters. I've just realized I gave you the other word. Anyway, it's fine. Sorry, can never be de-identified. For example, even a few gene markers may provide enough data to uniquely identify an individual, or I would even add a group of individuals, a family, say, or a clan, or a tribe, okay? There's a doctor called Khaled El-Imam, and who has described methods. Please Google this guy. He has a few articles online, and he described methods that may be used to ensure the risk of re-identification is very low. But he noted that improved methods for the identification of genome sequences are needed. And note that he said that there are methods to reduce risks, okay, but it doesn't eliminate those risks altogether. So as long as there's a 2% chance that there's a risk that this genetic information can be decoded, then we still need to be vigilant, so that we make sure that all the structures that are created, that are surrounding biobanks and collection and use of genetic information are of the highest security standards. Okay. He also posits that even part of a DNA even if parts of a DNA sequence are suppressed, a skilled geneticist can reconstruct the missing sequences based on information that's already out there, that's already in the public domain, that's already been researched. Okay, so you don't need the full genetic sequence to identify, to connect genetic information of, let's say class rep Ronnie to his name. So you only need a few markers, and then you'll know what his ethnic group is. You'll know what his genetic vulnerabilities are. He's predisposed to this illness or that illness. Let me not say an illness. I don't want to manifest anything. I'm just using this as an example. But yes, you don't need much to be able to reconstruct a genetic sequence and then ultimately identify a certain person with the genetic information, and thereby posing risk not only to the individual, but to his or her family members and their ethnic community at large. Okay. So there's, I think we mentioned this last week about this, the US Congress Committee on Government Operations, when they were discussing about designing genetic information. And it bears repeating, because this was actually a statement that was made in 1992 and is still as relevant now as it was then. And I'll read it out. The routine availability of identifiable genetic information about individuals may have effects that reach far beyond the provision of medical care. As the amount of detailed genetic information grows, society may be required to re-examine the basic principles of health and life insurance, review the rules that govern employment and hiring, reconsider the confidentiality rules that are part of the doctor-patient relationship, and in general, reassess the way in which individuals are categorized and treated in a variety of social and economic relationships. Okay, so keep that in mind, because that really, if I was to summarize this entire topic that we've been talking about, I would summarize it in this statement. Okay, so so then it leaves I think one of the takeaways from this, there are many takeaways we can take, but one we can take is that if we are going to talk about privacy, then we must embed privacy into the design. Okay, rather than adopting a firefighting model, we should have a proactive, not a reactive model. So even if we cannot foresee what new technologies may come up, whether it's new technologies for storage, new technologies for hacking, new technologies for obtaining or using genetic information, we must always think 10 steps ahead and embed privacy into the design of genetic encryption genetic anonymization, and so on and so forth. So that every system that involves genetic information, every aspect of it, the first thought or the first question should be, is privacy guaranteed? Is privacy guaranteed? From the point of taking the samples, the point of its storage, to its passing hands, whether it's between the doctor and the lab, or the lab and the biobank, or the biobank and researchers, that question must always be at the forefront of the design of such structures, to make sure that privacy is embedded in the design of genetic information structures and biobank structures and genetic lab structures, as opposed to firefighting and dealing with things as they come. Because by the time you're trying to deal with a fire as it comes up, there's already damage which cannot be salvaged usually at that point. Okay, so that brings us to a discussion on Greenberg. Who was doing the Greenberg? Fatma, are you there?
Yes, I am.
Okay, Fatma, the floor is yours. Do you have slides?
No, I have like a PDF presentation.
That's okay. You can put it up. Let me put mine down. The floor is yours.
Nuru was presenting. Nuru was sharing the screen on my behalf. So
okay, that's fine. That's okay. She can now present. Yeah.
Okay.
And who was doing Moore versus Regents University?
I was doing.
Thank you, Chelsea. All right, we'll start with Greenberg, and then we'll go, and then we will conclude with today's session. So over to you, Nuru and Fatma.
So this was my analysis of the case of Greenberg. The case of Greenberg versus Miami Children's Home. Canavan disease is an incurable and fatal genetic disease that primarily...
Not home. Hospital. Exams are in 2 weeks. Don't say home. It's not
Did I say home?
You said home.
I said hospital. Okay, let me not argue. Okay.
Unless I was wrong. Someone correct me if I was wrong.
OMG, home right now. Hospital. Case of Greenberg versus Miami Children's Hospital. Canavan disease is an incurable and fatal genetic disease that primarily affects Ashkenazi Jews. So after Daniel and Debbie Greenberg's two children were diagnosed with Canavan disease in 1987, they sought out a researcher by the name Dr. Reuben Matalon to study the disease. The Greenbergs provided Matalon with blood, urine, and tissue samples over the years. And when their two children died, they even donated pieces of their brain for the research. The Greenbergs tracked down over 100 other Canavan families around the world and persuaded them to donate blood, urine, and tissue samples as well together. And they established the Canavan Registry. It was a confidential database that collected epidemiological, medical, and other personal information about the Canavan families. So the Greenbergs additionally contributed financially to the research, including $100,000 seed grant. As Daniel Greenberg commented, all the time we viewed it as a partnership. Our model was the testing program for Tay-Sachs disease. That's what they hoped would happen. So in their complaint, the plaintiffs alleged that they provided Matalon, the researcher, with all the bodily property, personal information, and financial support, with the understanding and expectation that the samples and information will be used for the specific purpose of researching Canavan disease and identifying mutations that could lead to carrier detection within their families and benefit the population at large. They also alleged that it was their understanding that any carrier and prenatal testing developed in connection with the research for which they were providing essential support would be provided on an affordable and accessible basis, and that Matalon's research would remain in the public domain to promote the discovery of more effective prevention techniques and treatments, and eventually effectuate a cure for the disease. So Dr. Matalon succeeded in isolating the gene responsible for Canavan disease in 1993, and a patent application was filed in 1994. The Miami Children's Hospital received the patent from the United States Patent and Trademark Office in 1997, with Matalon listed as the inventor. As a result of this patent, Miami Children's Hospital gained the ability to restrict any activity involved in the Canavan disease gene, including carrier and prenatal testing, gene therapy, and other Canavan disease treatments involving gene and its mutations. So the plaintiffs claimed they were unaware of the patent's existence until November 1998, when Miami Children's Hospital announced its intention to limit Canavan disease testing through a campaign of restrictive licensing of the patent. Miami Children's Hospital sent letters to Canavan testing laboratories threatening to vigorously enforce their intellectual property rights relating to carrier and patient DNA tests for Canavan disease mutations. So the plaintiffs claimed that they were unaware of the intention of Miami Children's Hospitals to commercialize the findings of this research, and that if they had known, they would not have contributed to the project. They claimed they were unaware of the patent's existence, and until November 1994, when Miami Children's Hospital announced its intention to limit Canavan disease testing through a campaign of restrictive licensing of the patent. They argued that this form was inadequate because it failed to disclose the researcher's commercial interest, describing the defendant's purpose only as identifying mutations in the Canavan gene, which would lead to carrier dictation within their families and benefit the population at large. So one of the parents that was also part of this shared that they gave their samples to be used for the public good, and they were not given to Miami. They were not given to Miami Children's. Had they told them that they wanted to patent, then probably they would have found another researcher who had the same goals as they did. To find the gene is not an impossible task as it seems. So according to one scholar, Miami Children's Hospital had a two-stage licensing plan to market the gene patent. In the first stage, a limited number of academic labs will be granted non-exclusive licenses to perform a limited number of tests at a fixed price of $12.5 per test. And in the second stage, they would license a large commercial lab as a market leader with an exclusive license to the remainder of the testing volume, allowing the lab to engage in monopolistic pricing. So the plaintiff filed suit against defendants, Dr. Matalon and Miami Children's Hospital, asserting 6 causes of action. One was lack of informed consent. The other one was breach of fiduciary duty. The third one, fraudulent concealment, conversion, misappropriation of trade secrets, and unjust enrichment. So the plaintiffs sought a permanent injunction to prevent the defendants from enforcing their patent rights, as well as damages, including all royalties defendants received on the patent and the return of financial contributions made by the plaintiffs to support the research. Except for the claim for unjust enrichment, the district court granted the defendant's motion to dismiss all of the plaintiff's claim. The court dismissed the claim for lack of informed consent, distinguishing itself from Moore on the grounds that Dr. Matalon was acting as a researcher and not a physician, and thus he owed no legal duty to the plaintiffs who are not his patients. The Moore case is what will be presented by my next colleague. So the court also ruled that even if a medical researcher has a duty to seek informed consent, this duty does not require disclosure of the researcher's economic interest due to the practical implications of imposing such a duty retroactively. The court specifically stated that such a duty will be unworkable and would chill medical research, as well as that it would give rise to a type of dead hand control that research subjects could hold because they would be able to dictate how medical research progresses. Based on similar reasoning, the court dismissed the plaintiff's claim for breach of fiduciary duty, concluding that there is no automatic fiduciary relationship that attaches when a researcher accepts medical donations. Nonetheless, the Greenberg Court relied on Moore to dismiss the plaintiff's conversion claim, holding that the plaintiff's body tissue and genetic information or donations to research with no contemporaneous expectations of return, and thus conversion does not exist as a cause of action. The court stated that property rights in the body are limited and that property rights in blood and tissue samples evaporate once the sample is voluntarily given to a third party. The court also rejected the plaintiff's argument that the genetic information contained within their bodies constituted a separate property interest distinct from the tissue itself. The court acknowledged that where information is gathered and arranged at some cost and sold as a commodity on the market, it is properly protected as property, but reasoned that this argument provides more support for property rights in the defendant's research rather than donations of the plaintiff's DNA. The one claim allowed to proceed by the Greenberg Court was unjust enrichment. It never went to trial because the parties eventually reached a settlement agreement in exchange for Miami Children's Hospital's promise to allow free use of the gene in research to cure Canavan disease, including gene therapy research and genetic testing in peer research. The plaintiffs agreed to drop their legal challenge to Miami Children's Hospital's ownership and licensing of the Canavan gene patent, for which the hospital would continue to collect royalties for clinical testing. That's the end of my presentation.
All right, thank you very much, Fatma. Any questions from the class? Any questions? I want us to next, so that we can now discuss and compare the Greenberg case. I think the facts, thank you, Fatma, by the way, that was a very good presentation, very clear and concise. You've brought out certain issues that the court considered: conversion, ownership, breach of fiduciary duty, etc., which were also dealt with about 13 years earlier in Moore versus Regent University. And Chelsea, the floor is yours to present on that. I want us to keep in mind that the 13 years difference, the considerations of the court in both cases, because the Greenberg case relied on the Moore case, okay, for issues on conversion and ownership, etc. Fatma, just remind us, in the Greenberg case, what did the court allow? What claim did the court allow? Just remind us so that we keep that in mind as we're going through Moore versus Regent.
The court only allowed an unjust enrichment.
Okay, on the grounds that, what was the explanation on that? What was the rationale for allowing the claim for unjust enrichment? Hello, can you hear me, Fatma?
Yes, I can. Just give me a minute, sir.
I'll give you 30 seconds. In the meantime, I want to also you to consider the UNESCO Declaration on Human Genetic Data. When did it come into force? Anyone? Yes?
The one claim that wasn't allowed to proceed was unjust enrichment. because
That was or wasn't?
it was allowed to proceed.
Yes,
That was
because
the only thing. Because the parties. Wait.
what did the court say? What were the court's reasons for allowing the claim for unjust enrichment?
I don't think I proceeded with that. Let me check.
Anyone who can help? Anyone who also looked at that case, the Greenberg case? Franklin, David Musena, Deborah. I asked a question. What was the reasoning behind the court allowing the claim for unjust enrichment? Deborah, are you there? Deborah, David, and Franklin, I want to hear your voices as Fatma is searching. Remember, I don't want any coasters in this class. Because also I don't like marking receipts. They're boring. And no one here is getting a receipt. I don't like setting receipt papers because the questions are usually 10 times harder than the main exam. So show me that you are understanding and you are with us. Otherwise, I'm expecting three fails in this class from Franklin, David, and Deborah. Yes, Chelsea, go ahead.
This is just a very random attempt.
That's fine.
I think the reasoning behind, the court allowing for the claim of unjust enrichment, I think there are certain elements that must be present for, the court to allow such a claim. And I believe one of them is that, the plaintiff conferred a benefit upon the defendant. And then the second one is that the defendant accepted and retained that benefit voluntarily. And the third one is that, under the circumstances, that, it would be unjust or inequitable for the defendant to retain, the benefit without paying for it. So I'm just suspecting that maybe as a result of the plaintiff having sort of exhausted these elements, then I believe that could have been a reasonable ground for, the court to allow or to support the claim for unjust enrichment that had been presented by the plaintiff.
Okay. I hear Fatma, yes?
I wanted to say that in order for the court, in order for a court to rule in favor of unjust enrichment, according to my understanding, the plaintiff must demonstrate that they have suffered a loss or a deprivation, and then the defendant, if the defendant has been unjustly enriched as a result of that cause, so the court will go on to determine an appropriate remedy that will involve ordering the defendant to pay restitution or any other remedy that is suitable to the plaintiff, or to disgorge the profits they have made from the unjust enrichment. That's my understanding. I don't know why I don't find the ruling and I didn't look at that, but yeah.
Okay, thank you, Fatma. I appreciate the attempt, and you are on the both of you are on the money. Arike, do you want to add something?
No, so now it has been covered, because I was thinking, if we go back to the question of consent, of why exactly you got the information in the first place, so that then you turn around and get some sort of monetary value from the information which was not initially you did not discuss with the patient, then you have unjustly enriched yourself on the word is not benefit. I'm looking for it's almost like you have taken advantage without the consent of this person. So like to just connect it with what Chelsea and Fatma said, and in the presentation of the case, it was not initially it was not the hospital was not supposed to get this commercial benefits from the research that they did without the person's consent. And then if you go ahead and get it without their consent and without them getting any of the benefits that you're getting, then you are unjustly enriching yourself. The word that I'm looking for is gone, but it's kind of
to the detriment, I think,
yes,
of the other.
Yes, to the detriment of the other party. So that is how I think why the claim of unjust enrichment is the one that succeeded. Yeah.
So yes, I think you're all correct. Let me just read very clearly what the court stated in regard to that, and the court basically stated that because this was a case that was heard in the Florida court. Okay, so it was saying that for conditions of unjust enrichment to be met, then the following must exist: that the plaintiff conferred a benefit on the defendant, that is those children. Remember, the facts are always relevant. You start with the facts and then you go to the law and you apply the law to the facts. So there's a group of Jewish children who are suffering from this Canavan's disease or were susceptible, and that meant they were dying before they reached the age of 5 or 6 or something like that. And the reason that these researchers at the Children's Hospital were given that they were given that genetic tissue for a specific purpose. Now they went over and above, found out what the issue was, what the genetic markers were, created a drug, and then went ahead and commercialized it without any reference to the people who had given them the actual raw material to do the research on. So the court was saying that the conditions that have to be there for you to succeed in a claim for unjust enrichment is A, the plaintiff conferred a benefit on the defendant. So in this case, the plaintiff or the plaintiffs, who are the children, conferred a benefit on the defendant, who was the researcher, and who had knowledge of the benefit they were going to get. The researcher had to be conferred a benefit and had to know what that benefit was. The second thing is that the defendant voluntarily accepted and retained the benefit. So that the research hospital, the Children's Hospital, voluntarily accepted and retained the benefit. And under the circumstances, it would be inequitable or unfair for the defendant to retain the benefit without paying for it. Okay, so those were the requirements that had to be fulfilled for the plaintiff in Greenberg versus Miami Children's Hospital to succeed on the claim for unjust enrichment, which ultimately they did, but they failed on the other claims. Okay. I'm trying to find something that specific judge who mentioned something to that effect. I can't find one at the moment, but those were the requirements that needed to be fulfilled before you can succeed in a claim for unjust enrichment. Okay. Let's see. Let's see what I can find. No, I can't find a specific judge's quote. Anyway, that is fine. So, sorry, is there someone who had a question? Yes, I heard something. Yes, Fatma, go ahead.
I don't have a question, but my main challenge was finding like the exact words of the judge who said, who explained in detail what unjust enrichment was. And that's why I didn't include them in my PDF, because it was people quoting words and saying ABCD happened, ABCD. So I didn't want to create a conflict of interest when I'm presenting. And that's why I didn't include the detailed part of unjust enrichment, but I read about it and understood some aspects of it. But your explanation has like boosted my understanding of it. So if it is founded, like someone just shares the exact words that the judge said.
Yeah, that is fine. No, that's not a problem. And also, there's something also I wanted to add, because this concept of unjust enrichment has caused some, has been the subject of a lot of discussion and debate. And some commentators have defined it as a quasi-contract, that unjust enrichment comes from or is born of a quasi-contract. And it was defined in this case called Kozlowski versus Kozlowski, or rather a quasi-contract was defined in that case, where it stated that a quasi-contract is a legal concept rationalizing a sanction to prevent unjust enrichment based on the equitable principle that whatsoever is certain that a man ought to do, the law supposes him to have promised to do. So now this is where the ethics comes in, because there's no necessarily codification of unjust enrichment. As someone has stated earlier, a lot of times when there's no clear-cut law or provision in the codified law, i.e. statutes or conventions, then we revert back to the common law on, equitable principles, fairness, remember your equitable maxims, all of them. I can't think of one specific one that is relevant to this, but basically, in this case, Kozlowski versus Kozlowski, they connected a quasi-contract with this concept of unjust enrichment. So basically, that what a man ought to do, then the law supposes him to have promised to do. So if in this case the researchers these people came to the research and said, our children are dying before they reach a certain age. We need some research. We know you can do this. You're a children's hospital. That's what you are created for, etc. And they accept, knowing full well that the result of this will be a greater understanding towards this disease, and potentially we can be able to find a way to combat this disease so that children are not dying before the age of 5, or rather Jewish children are not dying before the age of 5, because as has been stated earlier, this disease was specific to a certain group of people. Okay, remember, genetics and genetic information, how they can give information about a certain group of an individual or a certain group of people. So obviously not all the Jewish children were giving their samples, but the result of this research from the few who did give their samples would be creating a drug that would benefit all Jewish children, okay, by giving them, whether it's a vaccine or a medication to heal them, etc., etc. So now this is where this concept of unjust enrichment was now inserted into this decision when trying to considering whether the unjust enrichment claim would succeed or not. So it's basically an equitable principle based on fairness and ethics that whatsoever it is certain that a man ought to do, the law supposes him to have promised to do. So where that person has not fulfilled that promise or has broken that promise, then there should be consequences to that. Yes, Arike?
Yes, I have gotten the word. Ibrahim has sent it in the group. What the word I was looking for, it was not detriment, it was expense. So like what you're explaining, that at first the agreement was to help the Jewish children, and now you are commercializing it, and you're getting commercial benefit at the expense of this person, and so you are unjustly enriching yourself. The word I was looking for throughout that explanation was at the expense, not detriment.
At the expense. Okay, I had expect. So yeah, at the expense. Yes, I agree. Okay, thank you for that. I've just put the Kozlowski case on the chat and what it refers to, or what it discusses. Are there any questions up till there? Any questions before we go on to more? Because now more we're going to start comparing, and we need to understand that concept, especially of unjust enrichment conversion. What do you understand by conversion? Let's, in fact, before Chelsea starts, let's go through all. Fatma, you there?
Yes, I'm there.
Put up your PDF and go to where you had listed the issues that were considered by the court.
Oh my God, can I? Okay, let me try sharing through my phone. Or I share it with someone to present on my behalf.
That is fine.
It's fine. Okay, give me a minute, then I put it up.
Okay. All right. Chelsea, Wanjiru, just be on standby with your slides so that we can go up to it when we finish going through this.
Can you see my screen?
Okay. Can everyone see Fatma's screen? It's the first time I'm seeing a presentation from my phone, so I don't even know how to make it bigger.
It's kind of hard to like present from my phone, and I didn't carry my laptop, so.
It's okay. Just put it up so I can read it, then I'll put it in the chat.
Okay.
Just zoom it in as much as you can from your phone. Zoom some more, or is that the most? Okay, hold on. I'm also zoom on my side. Okay.
You wanted like the informed consent.
Yes, that list. I've just seen it. Yeah. Just zoom in on that so that everyone can see. Deborah, can you see what's on the screen?
Yes,
Oh, so you're alive. You're not a bot. Okay, good.
I can see it.
David, can you see what's on the screen? Franklin, can you see what's on the screen?
Hello?
Okay, so I guess Franklin and David are not in class. I'll mark it as such. Right, so what do we understand? Okay, we already know about lack of informed consent. We've gone through it in detail. What about breach of fiduciary duty? When does fiduciary duty arise, ladies and gentlemen? Arike, go ahead.
A fiduciary duty arises from a contract or from not only a contract, it can also arise from other relationships. So I'll give examples. A bank has a fiduciary duty to its clients so that you will not act in a way that is negligent or it's contrary to your client's interests. Also, some other relationships give rise to fiduciary duty. For example, if you're holding someone's property in trust, then you have a fiduciary duty to that person to not act in a way that is contrary to their interests. Other people who have fiduciary duties to other persons are, for example, executors of a person's estate. You have a fiduciary duty to the beneficiaries of that estate to not act in a way that is contrary to that person's interest. So it's not only in a contractual relationship where a fiduciary duty can arise, and fiduciary duty is enforceable by law if you act in a way that is contrary to the interest of the person to whom you hold a fiduciary duty to.
Good. That's, I think, what is basically what fiduciary duty is. Other instances of fiduciary duty is a duty of a director to the company and to the shareholders as a caretaker of the company to make sure the funds are not misused, to make sure the company's property is not misused, to make sure they don't act fraudulently and put the company's investments and the shareholders' investments at risk. Another instance of fiduciary duty is a doctor and patient. There might not be a written contract per se, but there's a duty of care that arises. It's kind of linked with tort and negligence, and because when you breach it, then you are said to have been negligent. when you breach a fiduciary duty of care or any duty of care, then you can be said to have been negligent in breaching that duty. Another fiduciary duty is between lawyers and their clients. So what you're going ultimately studying for, aiming towards, is a fiduciary duty to keep their information confidential, even from the state, even from KRA, even from, unless otherwise stated by law, or unless the client has waived that duty of care, has waived that fiduciary duty and said, yes, you can give that information. Yes, you can tell this government entity about this information that I've given you as part of our relationship as a lawyer and a client, and so on and so forth. So, okay, so now we understand informed consent. We understand what a fiduciary duty is. What is fraudulent concealment? As pertains to this course or in general, what is fraudulent concealment as a concept, as a legal concept? What is fraudulent concealment? What is it defined as? Let's see who has not spoken. Bosco. Bosco, are you there? Deborah and David and Donald and Franklin, I'm giving you an opportunity to say something so that I'm sure that you're not going to be here for receipts in September. Go ahead, Bosco. Mm-hmm. And deliberately with an aim to do what? Okay. All right. Very simple. Okay. You're concealing on purpose, yes, but with the knowledge that you want to defraud someone else. You want to steal a match on someone else. You are, because just withholding information in of itself does not make it fraudulent. It's the intention to be fraudulent that makes it fraudulent concealment. Okay? All right. Thank you, Bosco. Conversion. Franklin, what is conversion? Franklin, are you there? If you don't respond, I'll mark you as absent. And you need to be present for you to attend the exam. You need to have 100% attendance, I believe. And that goes to David and Deborah. Donald, are you there? Hello? Hello, Arike wants to answer, but you people are holding her up. Deborah? Deborah? Okay, Deborah is not there. Franklin, are you there? Okay, Franklin is not there. David, are you there? Donald, is Donald there? Okay, mark them as absent. Thank you. All right, go ahead, Arike.
Conversion, how to put it? So it's the possession and control of someone else's property in a way that is contrary to the interests of that person. So I'll give an example because I'm better with examples. If you have someone's car and then you go, you keep that car and you maybe spray paint it in a color that is not the color that that person wants, or even, for example,
let me pause you on that example you've given. What was the purpose for which you are in possession of the car and not the owner?
It could even be you are getting it on hire purchase, or you have rented the car, the way people rent people's cars, and then for a period of time. Yeah, that's even better. You've rented the car for a period of time, and then you're supposed to return it, and then you go and spray paint the car and change the rims in a way that is contrary to you do something with someone's property in a way that is contrary to the interest of that person. So conversion as a tort is not, it's not that you wanted to do something wrong with the property. It's simply that you acted in a way that is contrary. One, you have possession of another person's property, and two, you acted in a way that is contrary to that person's interest. Then the tort of conversion arises from that.
Okay, good. And I'm glad you've mentioned that it's a tort as well. Okay. And in this case, we're talking about conversion of human tissue, because there's a whole discussion about do you still own your blood samples and your tissue samples? For example, if someone does a biopsy of an internal organ of your skin, and you've given it to the biobank, do you still own it? Or have you given it away and you've lost ownership? Is there ownership in body parts that are not on your person? Of course, you own your body parts if they're hanging off you, your arms, your legs, your ears, whatever. But once they're off you, do you still own them? For a heart transplant, heart is quite drastic. A kidney transplant, once you've given your kidney away and it's been transplanted to someone else, and let's say that was your best friend, then the day you fall out, can you demand your kidney back and say, give me my kidney back? You insert expletive there. Can you go to court and say, I want my kidney back because this person who was supposed to be friends, I gave them my kidney, and now we are fallen out and no longer friends, I want my kidney back? So those are the questions that conversion deals with, okay? And then finally, what was the other one? Misappropriation of trade secrets. What is that concept, that legal concept? What do you understand by it? Anyone? Yes, Erike?
So this is an attempt. We've already talked about trade secrets sometime when we were talking about patenting. So a company has a way of doing things, and if they belong to that company, then you are required to protect them. So I would think if you act in a way that is contrary to that, to whatever. I've lost my train of thought. So you have this.
Your steps.
Yes, you have this. Let's say, for example, you're with Coca-Cola, and Coca-Cola has its trade secrets, and you go and use these trade secrets. I'm sorry, my train of thought is lost. I don't know where I lost it. I'll try again.
That's okay. When it comes back, just put your hand up, and then we'll come back to you. Okay. Yes. Anyone else would like to attempt?
Like in other words, I'd say that it occurs when someone acquires a trade secret in an improper way, like improperly discloses or uses the trade secrets without consent, or having a reason to know that the knowledge of that trade secret was acquired through a mistake or accident. Because as the last speaker said, since we are aware of trade secrets, the word misappropriation is like you're using something improperly. You are not using it with consent of the other party or having reason or knowledge of that secret. That's how I'll put it, my understanding.
That's good, Fatma. And then let's put it in context. So what in this case led to a misappropriation of trade secrets claim? What were the facts in this case that led to that claim being made by Greenberg on behalf of the children and their parents, their families? Because what had the hospital gone and done after they discovered what the issue was, the genetic issue was? What did the hospital go and do?
They tried to the hospital tried to sell the content.
Before selling, they tried to do what?
To use the...
Before using, they tried to do what?
Patent.
Thank you.
Oh,
they tried
patent.
to... Yes.
Okay.
Exactly. They tried to patent it because obviously they wanted to make sure that they were the only registered owners of that medication and that genetic material that they had found out or discovered or manipulated. So for them to get full advantage or commercial advantage, they had to go and patent it first. And we all know about patenting by now. And then they start going and commercializing it. So that now anyone who tries to copy what they have found out will be what? Will be in what? Will be doing what as regards the patent that they had obtained or tried to obtain. When you breach a patent, you are, what's the legal
Infringement.
term? Infringement. Okay. And that infringement, therefore, Fatma, as you correctly just stated, leads to the misappropriation of trade secrets. Okay. Arika, you wanted to add something? You found your train of thought?
I have, but it has been explained perfectly by Fatma.
Okay, good. I like when a plan comes together and everyone is happy. So do we have any questions until there? Before Chelsea, I give Chelsea the floor to close for us with her presentation on more. Okay, Chelsea, floor is yours. Thank you, Fatma. You can put the slides down. Yes, thanks. Yes, Arike? Chelsea, go ahead and put up your slides as Arike asks the question.
I was trying to think, you've taken away the slides.
Oh,
There's one of these thoughts. I think...
sorry, what was the...
I don't know what is with me today. I keep losing what I'm thinking. I will write it on the chat.
Yeah, I was about to say, write it on the chat or write on a pen and paper as it comes to your mind. Because I suffer from that a lot. So I understand. Okay. All right. Chelsea, go ahead. Do you have any slides to put up, or you're just going to give us a TED talk?
Okay. I'm going to discuss the case. I don't have any slides.
That's fine. Floor is yours.
Okay. The case is Moore versus Regents of the University of California. This is a case between Moore and the Regents of University of California are there's Gold, who is a physician who treated Moore. Then there's Kwan, who is a research assistant of Gold. Then there's Sandoz. Sandoz Research Institute. Moore was being treated for leukemia by Gold, who was his physician, and his spleen grew grew in size, and the hospital advised that his spleen be removed. So the spleen was removed because it was swollen. When the spleen was removed, Moore's physician, now Gold, realized that Moore's white blood cells had grown back to the same, or had grown back very fast, and he realized that there was something unique in Moore's white blood cells. So he started doing research on Moore's white blood cells. Now the patient used to come for visits, checkup visits at Gold's hospital, or the hospital where Gold was operating from. But eventually he moved, and Moore asked the Gold if he could get a doctor nearby, but Moore advised that he should still come back to the same place. All this while, Gold had realized that there was something special in Moore's white blood cells, and that's why he was doing research on them. That's why he insisted that he keeps coming. He even offered to cater for his accommodation and transport. So now, later, after some visits, Moore became suspicious of consent form that he was being asked to sign, and he sought legal services, and he realized that there was a patent on his cell line. The patent was called Moore, now MO. And under the patent, he realized that Gold and his research assistant, Kwan, had been named investors, and there was an agreement with Genetics Institute, and Gold had become a paid consultant and had 75,000 shares of common stock. And they had also agreed to pay Gold and the regents of University of California over a period of 3 years in exchange of exclusive access to the materials and the research performed on the cell line derived from it. Mon, learning this, decided to sue them for using his cell line and benefiting from it without his consent. I'll compare the issues brought to the court were more or less or similar to the same ones of the case we have just done before, on informed consent, on conversion, and on unjust enrichment. On conversion, the court decided that a patient does not have absolute property rights over his body tissues. The rationale behind this was because conversion is a strict liability tort. We've just been told that it's a tort, it's a strict liability tort. So making and the case will create precedent. So now granting conversion or making it actionable in this case would mean that any lab or any research institute doing research or carrying out research on tissues from a human, from any person that have already been removed, they would have to follow up and gain consent from the patient, and it will affect medical research, because people do research. Anyone who will come in contact with the tissues from someone else, tissues that have already been removed, would have to now gain consent and will be liable, will be prone to getting sued under conversion. So the tort of conversion here was not, it failed in his case, but later it was said that Mo, after the case now, Mo agreed Mo got into a token agreement with the University of California, regents of University of California, and he was compensated for his legal fees, and because of the fact that he did not give informed consent on his samples being used, on his tissue samples being used. I think that's it.
Okay, so what were the issues that were considered in the Moore case? Remember, the Moore case was determined in 1990, some 13 years before the Greenberg case, and the Greenberg case actually relied on Moore under those headings of conversion, the headings of unjust enrichment, and so on and so forth. What were the issues that were considered in coming up with the decision in Moore?
The implication of the case, or the decision they would come up with in the field of medical research, the rights of patients in relation to their biological materials.
Mm.
Yeah, those two. On the rights of patients, the court ruled that individuals do not have an absolute property right in their own cells once those cells have been removed from their own bodies. But it recognized that they have a right to control the commercial use of their genetic information, and that medical professionals have a duty to disclose any potential conflicts of interest. So in this case, he did not have absolute property rights over his tissues or his cell line, and also because they also stated that his tissues or his white blood cells were not any unique, that a lot of research had been done to develop this cell line had been done by Gold, his physician, to develop this cell line that now became a patent.
Okay. So in the Moore case, did they allow the conversion claim or did they reject it?
They rejected it.
Okay.
Yes.
Very much in the same way that that Greenberg did. But there was a dissenting opinion in Moore. I don't know if you came across that.
Yes, I also came across it. There was a dissenting opinion by one of the judges.
Mm-hmm.
He said that at the very least, Moore had the right to do with his own tissue what the defendants did with it. That as soon as the tissue was removed from Moore, he at least had the right to choose to either sell it to these regents or to these researchers or have it destroyed.
Mm-hmm. And also, when we look at the facts between Moore and what is the defining difference in the Moore case as far as the facts are concerned as compared to the Greenberg case when it comes to consent? What was the defining difference?
If I could try, in the Greenberg case, the parents of the children who are suffering knew what they were doing, and they knew they are contributing the resources and also the tissues or the biological material of the children into research. Here, Moore was just coming for treatment, and he gave consent to his bodily material being removed, but he did not do it with knowledge or information that his biological material is being used for research.
Mm-hmm. Exactly. And that had an impact on obviously on the Greenberg case, but more so in this case. Okay. When it came to the decision. So what claims did the court allow, just as a summary, and which ones did they reject in the Moore case?
In the Moore case one, you said they rejected the conversion.
Mm-hmm.
Because they also rejected the court held that the unauthorized use of a patient's cells for commercial purposes could not constitute a violation of informed consent and a breach of fiduciary duty. But the court concluded that Moore's claims were not actionable because he had not suffered any legally recognizable harm as a result of the use of his cells.
Okay. What do we think about that decision? That because potentially what they're saying is that that Moore could have won, they would have allowed a claim on conversion only because of the facts of the case, that Moore was clearly in the dark about what his cells were being used, was not no informed consent was asked of him. And he should have, because, and this is also to try and maybe answer Arike's question in the chat, would have probably succeeded in the conversion claim, only that the court determined that because there was no legal damage that he suffered, then he would not win on that. What is your opinion? And this is also to the class in general. What is your opinion of that decision?
Okay. My opinion, the reason as to no damage suffered, I think the main reason why the court rejected this claim was because of the effect of allowing it. That makes sense.
The effect. You're on the money, Chelsea. Go ahead.
Yeah, because here the doctor did it. Okay, not fraudulently, but he hid it from him. Where you said he intentionally withheld information from Moore by even offering to pay his accommodation and insisting that he doesn't get another doctor nearby, that he should still come for visits. But in other cases or in other instances that would come afterwards, the doctors may not be withholding this information with any intention or purpose to gain from it fraudulently, but if the judges had allowed the claim of conversion in this one, it would affect the forthcoming cases, because now medical research will be hard, because if the patients still have absolute property rights over their tissues long after they've left their bodies, it will be hard to carry out research, medical research.
Okay. Thank you very much, Chelsea. That was a good presentation. Any questions there before I add my 2 cents? And well done, Chelsea, for actually. This is how by the way, this is how the CAT will be when it comes to presentation. I will ask you questions, and you will actually be marked on how you respond to those questions, and whether you take up the challenge, whether you keep quiet, whether you pass it to your teammate, etc. Because the whole point of asking questions is to interrogate how you're connecting with the material that you've been assigned. So as of now, the way if had me asking Chelsea questions and she has responded, Chelsea would score very highly on that alone, on top of the presentation. So well done, Chelsea. I just want to put you all on notice so you don't go quiet when I call your name, as certain members of today's group have, whose names I shall not mention. Franklin, Deborah, David. Oh, sorry, I said I wouldn't mention them. Okay, I see a question up there. Arike?
Yes, so the problem or the observation I had in the last case was about extending conversion to apply to genetic information, given, or just like the idea of conversion in medicine in general, given how divisible this information is. So that if for example, like in this case where he offered one of his body parts, from that body part you can get blood, and then the blood itself will have its own uses, or you can get a piece of it which will have its own uses, and then you can get cells from that, and even from the cells you can divide the cells to get even more different cells from that. So my question in the last discussion was how practicable it is, and how even how dangerous it would be if the thought of conversion is extended to genetic information, and which question the court and Chelsea have answered, because to me it does seem a bit dangerous, because just of the way the thought of conversion itself is styled, it's a strict liability thought which would put too much what is the word, obligation on on hospitals when they are doing this research. And then secondly,
yeah, sorry, I was agreeing with you. Yeah,
yes, it's fine. Secondly, on this case that we've just spoken about, on property rights, on not having property rights in terms of genetic information, there's one article which you had given a few weeks before. I cannot remember the topic of the article, unfortunately, but it was talking about this case and the idea of extending, no, actually it was the previous case, and how it was protected in terms of privacy rights, and how this would not work in the US because the right to privacy is not a constitutionally protected right, and so it becomes a bit less strong than it is in Iceland. And what would work better is extending property rights to this, not exactly conversion, but other property rights which can exist outside of the person, and extending it to genetic information. And I was trying to think about what the judge said, where the dissenting judge said at the very least they should have some property rights. And I was thinking of it in terms of Kenya, and in terms of how we can protect genetic information, because unlike the US, we have a constitutionally protected right to privacy, and we also have a constitutionally protected right to property. And something that we have that the US does not have is communal right to property. So I was kind of thinking of how we can apply that communal right, where a lot of people own the same have the same rights to one piece of property as a community, simply because of how culturally and historically they have owned that piece of property. And so if you apply it to genetic information, a lot of people have the same interest in genetic information, just based on the fact that they all share it, and you cannot divide how they share it so that one person owns it more than another person. So the genetic information is protected in terms of like the way we apply communal rights to property, then we apply this communal right to genetic information. And I think what makes it stronger for us than it is in the US, it's that also this communal right to property is also constitutionally protected, so that you kind of get a constitutionally protected right and then apply it to genetic information.
Sorry, I was talking, thinking I was not on, I was unmuted. Actually, what you have mentioned is very important, and I like the question that you've asked, you know, bringing about the extension of property rights to either to include genetic material or specifically for genetic material. And remember earlier on, I'd asked you to find out, someone to tell me in the class when the UNESCO declaration came into force. International Declaration on Human Genetic Information came into force, and that came into force in which year? Anyone? Okay, in 2003. Okay, that was when it was signed and by the member states and agreed by the member states. So that was, again, some 13 years after the Moore case was determined, and in the same year as the Greenberg versus Miami Children's Hospital was being determined. So then it begs the question that if this convention was there, okay, I need to find out whether America is one of the signatories to this. I would not be surprised if they're not. But the question becomes, would more have been determined differently, especially as pertains the issue of conversion, if the UNESCO declaration was in force at the time? Because as you can see, as has been stated very clearly by Chelsea and Arike, that part of the decision making when it came to conversion, the court did recognize that because there was no informed consent, that the conversion claim should be allowed, but because there was no legal damage, remember you're taught duty breach damage to bring a claim in tort in negligence, etc. They would not give conversion for the obvious reason that it would open the floodgate. So everyone who had a blood sample taken will start now suing hospitals and all that kind of thing. And also in a political kind of creative jurisprudence or decision making by the judges, they are also very cognizant of the fact that if they do allow claims of conversion to go through, and conversion claims are strict liability, there's no thought process, or rather there's no malice or any of these issues that are taken into account. It's either you did it or you didn't. And if you did it, then there's consequences. And if you didn't do it, then that claim will not survive. Because it's a strict liability, it would have the net effect of hampering research. And the general consensus is that we do need research to advance, our medical care, our health care, to advance all these kind of things, and even just the knowledge, the collection of knowledge and archiving of knowledge within the medical field. So the court felt that it was their responsibility not to allow a jurisprudence that gives a free-for-all for all and sundry to claim conversion on every single, mouth swab or, blood sample taken or biopsy done or anything like that. So there was a cognizance by the courts, both in Moore and in and in Greenberg to a certain extent, where they would not allow conversion to happen, or rather to succeed, because of those far-reaching concerns that they had. So it's very important that you keep that in mind, and also, bringing it back to the UNESCO Declaration. The question, if like what Arike was discussing, is there scope for legally creating property rights in human tissue and genetic tissue, specifically just for genetic tissue, that is separate from the concept of conversion, in alignment with Article 4 of the UNESCO Declaration, which declares that human genetic data requires special protection. Okay, so that's something that needs to be kept in mind. If this declaration, UNESCO Declaration, was in existence in 1990 and possibly in 2003, because both these two, the decision and the declaration, were being determined in the same year. I'm not quite sure which month was which, and whether one influenced the decision, whether the UNESCO Declaration influenced the decision in Greenberg, or whether it came after Greenberg was decided. Those are considerations that need to be kept in mind, because then maybe the issue we would not be talking about conversion, we'd be talking about specific and separate property rights in genetic human tissue to prevent them from being misused or abused by researchers. Okay, and then also please note that in Greenberg, as Fatma presented, the reason why fiduciary duty did not apply in Greenberg and would have applied in Moore, because in Moore, it was Moore's doctor who was actually taking his tissue sample, whereas where a fiduciary duty applies. But in Greenberg, it was a researcher directly with the parents. So he was not treating them, he was not their doctor, he was not their physician. Therefore, the fiduciary duty did not apply in Greenberg. And that's why that claim failed in Greenberg. Did Chelsea, did the fiduciary claim, was it claimed in Moore? And if it was it allowed? Was it successful? The breach of fiduciary duty?
It was claimed, but it was not successful.
It was not successful. And why wasn't it successful in Moore?
Because of the same about legal harm.
Legal harm.
Legally recognizable harm.
Mm. And for those students of jurisprudence, what is the school of jurisprudence that talks about, I think it's legal realism, where the laws are made in the courts, and where the courts then, because obviously the people who are making the decisions are human beings who have backgrounds, who have biases, who have interests, who have prejudices, etc. That there is a discussion or analysis that that really the fiduciary claim should have succeeded and the conversion claim should have succeeded on the basis of the facts. That in Moore it was a doctor-patient relationship, and also the doctor willfully misled the patient more as to what he was actually doing vis-a-vis treating him, and also in obtaining his tissue samples. So the question becomes, if that decision was determined when the declaration was existing, would the court decide in the same way? And that's assuming that the US would have been signatories to that international declaration. Are there any questions still there? Any questions? Any observations? Yes, Arike, and then Ibrahim.
Ibrahim can go first.
Oh, sorry. Actually, yes, you're right. Ibrahim. Sorry, I was looking somewhere else.
you. Thank you. Malim, you have shared with us a lot of notes, and we really appreciate articles, all those reading materials. But
I hear where you're going.
the slides you are using also contain very pertinent and important information. Now that we are almost approaching the exam time, we really, really appreciate if you can give us also really finalized our stock of materials.
Yes. Let me get back to you on that one tomorrow. I'll get back to you on that one tomorrow. I generally, as a rule, don't give out slides because I worry that especially people who are not attending class will think that they're going to pass. And I don't want to give people a false sense of security. I'm not talking about you in particular, Ibrahim. I'm just saying I'd rather we ask questions and discuss in class than slides just be, some buzzword between people, and then people think they are going to pass and then they don't. And then they come and give me grief after they get their results. Trust me, it's a thing that happens every year, every semester, actually. So let me sleep on it and I'll let you know tomorrow.
Thank you, Malim.
All right, thank you for that. There was someone else. Oh, sorry, Chelsea, go ahead.
Right. Can you hear me clearly?
There's a lot of noise in your background, but yeah, go ahead.
My question is specifically on the initial condition. On the hard thing, I think that's not very clear because you talk about the principle and
Hold on, Chelsea. I can't hear you. Can everyone else hear Chelsea, or is it just me?
There's background noise.
Yeah, there's also background noise, Chelsea. Is there, okay, yeah, type it. Yes, just go ahead and type it. In the meantime, as she's typing, are there any other questions? Class rep, remind me tomorrow in the morning about Ibrahim's question so I can deal with it accordingly. Thank you, Bosco. Yeah, I suspected the US is not a party too. The US tends to be involved in creating these international agreements, but not wanting to be a part of them because they don't want to be bound by them, which is just a weird situation, or rather a weird position to take, but they are who they are, and hopefully things are changing soon. Let's see. Is the question up there? No, not yet. Thanks, Bosco, for that. Yes, Arike, go ahead.
Yes. So I was trying to think if the cases would have been decided differently if the countries that decided the cases were part of the declaration. Number one. Number two, I was also trying to see if I support the position of the court, and I don't know if it's a good or a bad thing, but I support the position not to extend conversion as a tort into what is it called?
Into genetic information.
Yes. It's the very same reason I do not support the WIBA having strict liability. I do not think medical things of this nature should be strict liability because there's so much involved that you cannot just say, oh, this happened, then you're liable, because there's so much explanation around it. And I think even in this case, like, there's no, the strict liability takes away the concept of malice altogether. So I personally agree with the decision of the court, both in Moore and in the what is it called? Both in Moore and in Greenberg, where to extend strict liability to genetic information would be unwise in my decision, because then like your genetic information once you've given it and you've given consent, will not be handled by one person. And I think this explanation was given by the court in Moore, that it involves such a large group of people who are handling this information, and to extend strict liability to another person having this information, it's a little bit dangerous, in my opinion. Secondly, on whether or not it would have been decided differently if it was what is it called? If the declaration was in place at that time, I don't think so, because the declaration seems to give a lot of power to domestic law. So it gives the general law that will be used, and then after that, if something is changing, then it gives the domestic law power to decide that. So, for example, in change of purpose, which relates to what we have been talking about, it says that that informed consent is supposed to be gotten from the patient, unless so it says informed and express consent of the person concerned is obtained according to the provisions of Article 8A, or unless the proposed use decided by domestic law corresponds to an important public interest and is consistent with the international law of human rights. So I see there's also a delegation to public interest, which again, both the courts in Moore and particularly in Greenberg, so the court considered what it would mean for research and for medical advancement in general, if the court was to apply the thought of conversion to genetic information in general, that it would impede medical research, because it's just very impractical in its nature, given how this how genetic information is processed and all that, and what it is used for. It's just impractical to have a strict liability tort applying to it. So I see it's my argument that even with the declaration being in place, and if a case of the same nature was to arise today, I still don't think conversion would have been extended to them, and I do not think it should be extended to them on a matter of public policy, because then it would make it very difficult for researchers to advance the medical field, because of how much obligation will be put upon them to keep getting consent over and over again. Every person is getting the consent of this person, because you have to ensure that you're working within their interest, and it's not just the very first person who got the consent who then has to handle the information.
Thank you very much. I think I'm inclined to agree with you. Applying the thought of conversion in this instance may not be practical or even desirable, as you know, in the sense of creating precedents, because that's our system. We work on precedent, and also it just would be totally impractical to actually to be impractical, especially for the researchers to actually be able to do their jobs, knowing that this strict liability tort is above their heads. And so it would need, a lot of impractical structures to be put in place, which then would impede on medical process, and then we would ultimately be the sufferers or the ones who bear the brunt of that. However, I'm not opposed to a separate legislation that specifically deals and sets out the parameters as far as ownership is concerned, because there is a danger of we've talked about instances before where researchers do abuse their position, and like in the Moore case, where there is deception and things like that, where there should be some sort of punishment over and above unjust enrichment, because as you're seeing in these cases, the court used the fact that there was no legal damage or damage occasioned upon very creative, actually, occasioned upon Moore and that was the reason they used not to grant him conversion, even though they did agree that, you know, the way his tissue was obtained was actually wrong, and informed consent was not given. Because as it stands with these two cases, it means the only claim that would succeed would be that of unjust enrichment. So what happens if all these facts are still there, but they don't go as far as commercializing? Does that mean that a wrong has not been occasioned, has not been done? I don't think so. The wrong still is there, but now by the mere technicality that they have not commercialized it yet, or patented it yet, but that information still remains there open to anyone to use within that institution, that research institution, etc. That means that potentially, if there's no commercialization, that potentially means that any claim will basically fail on all those grounds, including unjust enrichment. And it seems like unjust enrichment is the only claim that would be allowed by the court, if at all. Okay. Thank you for that analysis.
Just before we go to the next person, because it's going to escape my mind, I'm thinking of why exactly this failed, this unjust enrichment, on the basis that they have not yet commercialized, when, especially in the I think in the first case, it had been patented, and there's usually this anticipatory breach thing. I don't understand why the court cannot just extend this concept of anticipation to it, because once it is patented, there's no reasonable way one would think they would just patent it to just keep it there for the rest of the time. Definitely they want to commercialize it. So I do not understand why the courts are not applying the concept of like anticipatory, like something anticipatory, given the fact that it's not novel. We even have like anticipatory breach of contract. I see where this is going, and reasonably you are going to breach our contract. So I see where this is going, and reasonably you are going to commercialize you're going to commercialize my genetic information without my consent. So in this part, I have actually been thinking about it since the time I read this case. I don't understand why the concept of this anticipatory concept was not applied, given just reasonably someone can see that commercialization was definitely the next stage if they had already patented the product. In this one, if they had already, like, even they owned shares, they'd already sold to another company, commercialization was definitely the next step. So in this part, I don't understand why the court was not ready to extend that concept to it, given even the concept of this anticipatory concept itself was created by the courts, by them just extending the concept of breach of contract.
Yeah, I agree with that. I think maybe the court felt that, I suspect that it was not claimed or argued by the plaintiff about anticipatory breach of duty, about anticipatory commercialization. I suspect it wasn't argued. And even if it was, I'm not sure the court would want to deal in what is possible or what is not. The court deals with what is there in that moment. So the court probably would have had, or at least I've seen it happen here, they would say that until that breach happens, then bring that to court, then we'll deal with it. But we can't be dealing with anticipatory breaches or anything that might or might not happen in the future, because then that would be opening a whole other can of worms. So I suspect that would be the reason. But otherwise, I do agree. I do think the court was trying to be creative in upholding a policy where they did not want a decision that basically ties the hands of the research community, because there would be blowback onto the court, politically speaking. Okay, thank you for that. I like that analysis that you're giving, and it's really enlightening. And I'm hoping everyone is catching this and it's helping them also form their own opinions about these cases. I hope you've read them, because if you haven't read them, then there's no opinion to form of something you haven't read. Bosco, go ahead. I saw your hand up. Please go ahead. Mm. 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 Yeah. Mm. 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 And actually, that's a good point. I don't think that is off point at all, Bosco, because if you look at, I mean, the people who are bringing cases to court are people of means. So, and the people who this is probably happening to on a regular basis are people who are not educated, not sure about their rights, not even sure about what is happening to them or with their samples, etc. So this is why I think I personally believe it is really important, or was really important, for the court to make even though they do have legitimate reasons about not opening the floodgates, but it was important for the court to state emphatically and maybe even inspire the legislators in parliament to actually create specific laws that protect property, and also put the onus on the researchers as the stronger party. You know, in contract, there's the dominant party and the what's the terminology we use in contract? When you are not equally my brain. When there's in contract, when you're talking about parties who do not have equal strength, so a company or individual, what do we call that? They do not have equal bargaining power. Okay, so there's a difference in bargaining power. So the researcher obviously is backed by a hospital, by a lab, by a company, whatever, or university. And the individual whose samples are being taken most of the time is not very aware or keen to know the intricacies of the process. Or maybe all they're driven by is wanting to get better, wanting to find a cure, and all these kinds of things, wanting to survive, wanting to stay alive. So they might not be very keen to notice or to pay attention to ways in which their genetic material or their human tissue is being used, being misused, being sold and bought, being used to create medication, and people are registering patents and all this kind of stuff. And you're all there in the dark and completely unaware of what is happening and how your rights are being breached. So there's definitely, and so far these two cases they seem to have leaned on the side of the researchers, even though in Greenberg he did win on unjust enrichment. But I feel like that was just like, it was like giving a dog a bone, because you couldn't give them the meat. It's just something to say, okay, here's a consolation prize, because we don't want you to leave with nothing. And also, obviously, in the facts of that case, it was involving children who are under the age of 5, and that would have had, excuse me, that would have had political implications if a court is allowing a research lab to take advantage of young children. The optics are not good. So I feel like that award for unjust enrichment was probably, a consolation prize. But then there's a bigger discussion that needs to be had about how do we balance, the interests of having researchers not having their hands tied behind their backs, and the safety and protection of the owners of this, or the human beings who have this genetic material which is being used for research, etc. So there's still a balance that needs to be made. Yes, the UNESCO declaration is a way towards that, but it still remains to be seen with more court decisions how that UNESCO declaration is influencing decision making on matters genetic information. But yeah, that's definitely a concern, because a lot of the people who are being tested on, or whose samples are being taken for research and patenting, are not you and me. They're usually some kids from Kibra, you know, from Madari, from, you know, Ushago somewhere, and 9 times out of 10, they are completely clueless. So that's a good point to raise. I think, Chelsea, I'll give you the last word. Go ahead.
Right, thank you. I think now I'm in a more settled background.
Yes, can hear you now.
Yes, okay. I have 3 very brief questions. The first one relates to the cut. And I just wanted, I don't know if this one was asked maybe in my absentia. If it was, then I think I'll just catch up with my classmates. But the question relates to the submission clause in particular. You mentioned something along the lines of, you know, a pigeonhole, and then at the same time you mentioned something along the lines of, you know, the synopsis together with printed slides, you know, both hard copy, soft copy, and then the hard copy to be placed in your pigeonhole. So maybe you could just emphasize on that, because I'm not privy to your pigeonhole. And then the second question relates to, it's a very brief question. I think some time back, you told us that, you know, when it comes to like these key terms, I'm looking at a word like, you know, biobanking, for example. And my question is, when it comes to now bringing out the definitions, just a minute. Sorry, yes, when it comes to now the definition, would it be okay if maybe we relied on, you know, medical institutions, for example?
Or you can use, yeah, you don't have to be limited by the Oxford English Dictionary, because we're dealing with matters scientific. So you can start there if you like. I'm not saying don't use it, you can, but if you have another definition that is more concise and more importantly is helping you bring out the point you want to bring out, then by all means use it. Just make sure you reference it properly so it can be verified. With the cat, what I meant by pigeonhole, I'm just trying to realize that some of you might not be in Mombasa. My pigeonhole is just basically in the law faculty reception in Mombasa. The boxes on the wall, there's a pigeonhole with my name on it. So that's where to deposit the hard copies. But for now, because of time, emails will suffice. Just send all those documents. I need at the very least, the soft copy sent to me in advance, so I can go over them, grade the written work, and then the following day we do the presentations and I grade those as we present. Okay.
Right. Okay. And maybe just to follow up on that. So now, what purpose does, you know, Google Classroom serve if we are sending all the documents in advance via email?
Well, the thing is, it's easier for me to access email as opposed to Google Classroom. You can send to both, because I can access the email from anywhere on my phone, and the Google Classroom is not always convenient to access documents, but we can submit them there as well. There's nothing stopping you from submitting on Google Classroom.
Right, thank you. And I think my mind has come back to the question I was going to ask.
Okay, go ahead.
It's just an assumption. So hypothetically, let's say you bring us a hypothetical Kenyan, you know, related scenario. And maybe for that particular scenario, there isn't like a Kenyan case for it. Like maybe the case is from abroad, and then maybe you twisted it a bit with Kenyan names, etc., brought it to us. So I think this is a worry or a query, I don't know how to phrase it. But would it be detrimental for me as a student to heavily rely on, common law cases as opposed to like the Kenyan cases, bearing in mind that this unit is like Kenya hasn't really said so much about it if you are to compare it with, England or common law or something along those lines.
No, it's not. In fact, this is probably the one unit, I don't know about the others, where I expect case laws, especially case law, and other legal authorities from other jurisdictions which have had more experience in the science and technology field as it pertains to the law. So there's nothing stopping you. Of course, I would love to see Kenyan law. If you can find it, please bring it to the fore, discuss it. There's certain topics like science in the courtroom where I expect Kenyan law to be a feature there, because we have Kenyan jurisprudence on that. Maybe not to the level of Australia or the States, but we do have jurisprudence, and I expect that to be mentioned. On surrogacy, we have Kenyan law that talks about surrogacy, so that's not a new thing. So there is, where there's Kenyan jurisdiction, make sure you use it. Where there's Kenyan case law, I beg your pardon, make sure you use it. But I've also taught you on other case laws from other countries, so definitely include that in your answers, as long as you're properly illustrating and arguing your point.
Right. Thank you very much for that clarification.
All right. Thanks. Finally, I just want to, in Kenya School of Law, which most of you or some of you will end up at, usually CATs come with a requirement to hand in minutes of meetings and who did what and this kind of stuff. The reason I'm mentioning that is because in the past we've had situations where someone is assigned a group and then only one person is doing the work and other people are not communicating, not sending in their sections, or they're not want to meet and things like that. I'm not going to put that requirement, but if any such instance happens in your group where someone is not contributing, someone is not responding or whatever, I need to know. I don't want this thing of, snitches get stitches or whatever. No. In Kenya School of Law, it's even worse. So, because you have to go there and sign for your own work and identify what you did. So you might as well get into the rhythm of it now. I don't want on the date of presentation or the hand-in date, people saying, we didn't finish because so-and-so did not know. You all have a responsibility. You came to university alone. You have a responsibility to get your grades. So if there's someone who is blocking your blessings in that regard, let me know so I can do what needs to be done. And then you go ahead and get your marks. So that is, I need to make that very, very important. I need to make that very, very clear. It's important that I know well in advance so then I can take the necessary steps. Do not come with an excuse or reasoning that I didn't finish or didn't do this because so-and-so did not contribute. No. If they're not contributing, recognize that early enough, do the work, come and get your own points. I've had it in previous situations where a group of 5 people, one person does the work, and then on the day of the presentation, all 5 turn up. Yet, it is very clear that only one person did the work. In that instance, the other 4 who didn't participate got zeros. Very clear. I'm very, very, very clear on that. So don't suffer in silence. Equally, don't let someone ride on your back because it serves no purpose and it doesn't help you. I'd rather you do your work honestly than you rely on other people and then end up failing later on down the line when you get to Kenya School of Law or beyond. So I just want to make that clear. All right. So thank you very much. I appreciate your engagement. For those who have been showing up regularly and consistently and contributing, thank you very much. It actually makes such a difference to this course, especially because without interaction and engagement, then nothing really can happen. So thank you for that. I appreciate your contributions. It has made this semester actually fun to teach, which is not always the case sometimes. So thank you for that. Yes, so I look forward to receiving your cards next Wednesday? Yes, next Wednesday. and then we will do the CAT next Thursday, same time. So please be on time on Thursday and be prepared. All right, so without further ado, have a good weekend. Enjoy the CAT. Take it as the challenge that it is and as the revision opportunity that it is, kindly. So have a good evening. Have a good weekend. See you next week. Take care. Bye.
Thank you. Goodbye.